Division 1 is now in session.
Thank you all. Please be seated. This is a time set for oral argument in our case number CACR 160209, State of Arizona versus Jane Leslie Carpenter. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time for rebuttal. If you wish to do so, you'll need to keep track of your own time at the clock at the podium. Out of respect for counsel, I would ask that those in attendance make sure your cell phones are turned off so our conversation is not interrupted today. We have read the briefs. We've conferenced the case. We're familiar with the record. We'd encourage you to keep that in mind as you present your argument today. Our proceedings are being recorded and will be posted to the court's website and then onto YouTube. So that suggests or means that we would want you to tell us your name and the party that you represent as you begin your oral presentation. With that, Mr. Bloomberg.
Good morning, esteemed judges. My name is Bruce Blumberg, and for some time now I've had the pleasure of representing Jane Carpenter. Sadly, though, we know that criminal defendants have very little control over the criminal justice system. Therefore, they rely upon trial judges to, within the law, to provide the best possible playing field, following the principles that were set forth in Winship and followed by Jackson versus Virginia. And one of those plays in the playing field had to do with the Willits instruction. And in reading the Glissendorf case, Glissendorf 2, the Supreme Court, our Justice Scott Bales, who's now in the Court of Appeals for the Ninth Circuit, he celebrated the 50th anniversary at that time, I guess it was in 2014, of Willits itself. Willits is not a constitutionally required instruction. It is a court-made instruction, but it helps to level the playing field. And in Willits itself, Justice Struckmeyer said that the rule permits the instruction that even when there was no foul play, that evidence may be innocently destroyed through carelessness or negligence or an unwillingness to make the necessary effort to preserve it. In this case, folks, we had a crew of detectives whom really had very little, if any, experience in homicide cases. And I think counsel brought that out to a large extent with each detective who testified. But they failed to preserve some of the most important evidence in a case like this where there's really no solid evidence, as California justices like to call it, solid evidence upon which you can lay a foundation for guilt beyond a reasonable doubt in this case. It's all based on nuance and feeling and perspective of others, even a decade later. These detectives went to the scene. They believed when they were taking the vitreous fluid from the deceased's eye, from Brent Carpenter's eye, that that would help them establish the time of death. But within that decade before trial, Dr. Philip Keene, who's been with us for over 30 years as a medical examiner, told us that that theory no longer holds any water and that the time of death could not be determined. So the state relies upon something like barking dogs and moods and reactions to determine that Jane Carpenter was guilty beyond a reasonable doubt. But what they don't do is preserve the actual physical evidence that could have helped to exonerate her. Many of these cases talk about, it's virtually harmless error in some of these cases where, and I can name them and talk about them, but I'd rather first talk about why this case is not such a case. Ms. Carpenter relied upon the detectives to collect the proper evidence because this was a sort of interesting kind of ninja-like brutal murder with rocks. The victim struck from behind with rocks, whether he was on the floor or whether he was standing up. But it takes some sort of move to cause those types of indentations, and would have sprayed blood. And then the stabbing in the back, I don't know which happened. I don't recall which happened first. It's not significant for purposes of right this moment. And then finally, the slicing of the neck. Now, please understand, counsel was a little fearful at the time of trial because there was no evidence of whether or not it was left to right or right to left. Counsel for the defense was not about to raise that issue. So the jurors raised it. And they said, Dr. Keene, do you think this was left to right or right to left? While counsel held his breath, Dr. Keene explained that the wound appeared that it had been somebody slicing Mr. Carpenter's throat from left to right. At that point in time, we let out a sigh and later showed that Mrs. Carpenter was left-handed. Why is that not trumped up evidence? Because it was a decade earlier when she was being interviewed at the police station that she was making notes in a classic left-handed stroke with her left wrist bent. So naturally speaking, if you're going to slit someone's throat, you're going to go, if you're a left-handed person, right to left, and if you're a lefty, right to left, and a righty, left to right. That
Mr.
would
Bloomberg,
be,
what specifically, how are you alleging that the trial court erred in not providing a Willits instruction at the conclusion of the trial?
Sure.
Obviously, we've read the briefs and are familiar with the record, and I think you outlined 4 or 5 instances. What specifically should we be focusing on in terms of how the trial court allegedly erred in not giving a Willits instruction?
Sure. And Judge Bean, you'll recall that the judge said preliminarily, does everybody here agree that a Willits instruction will be given at the end of trial? So at the end of trial, we had a very lengthy, and I know you've read it, a very lengthy argument about the propriety of giving a Willits instruction. Judges, this is, how could you possibly not take the clothes, if you're a police officer, of someone who is at the scene and a spouse, so someone who might be suspect, how could you not take the clothes? So Detective Islas, who had so-called custody of Jane Carpenter, failed to preserve the most important and significant evidence by not taking Mrs. Carpenter's clothes on June 4, not on June 5. Now, further, Your Honor, Sergeant Cobble directed Detective Islas after the first time he directed him to take her clothes, and then at the interview he recognized she was still in the same clothes and said to him, take the clothes. His failure to preserve those is of enormous significance because of the possible detection of even the slightest microscopic blood from blood spatter. I asked each and every detective, Judge. I asked Detective File, Detective Islas, I asked our expert Streed, and finally Shane Reed, whom we thought was going to be one of our contrary witnesses and turned out to be one of our most favorable because he was a competent detective. He said, absolutely, you must take the clothes. And I asked each detective, could that evidence have tended to incriminate Mrs. Carpenter as well as exonerate her? And they said, absolutely. So there's no way that a government could contend, to your honors, that it's harmless error, that it wouldn't have helped. When you have so much...
Flesh out for me, as you've quoted Glissendorf, and that's really kind of the controlling case law that we have on this issue right now in Willits. Help me out with how, in Glissendorf, it states that a Willits instruction is proper if the and the defendant must show that there's a real likelihood that the evidence would have had evidentiary value. And you're saying it could implicate, it could exonerate. So tell me how this would have a real likelihood to have evidentiary value.
I'm glad you asked that. Judge, I was only being fair with the witnesses by opening the door, because if I said to each of the state's detectives, wouldn't this evidence have tended to exonerate Ms. Carpenter? They'd have said, well, it could have incriminated her as well. But of course, we don't have the evidence in order to demonstrate that because they failed to preserve it. In Glissendorf, Justice Bales said that there was two prongs. The failure to preserve material and reasonably accessible evidence. So it is material in the fashion that any forensic examination of this case, any scientific or empirical look at this case would say, was there blood spatter on Mrs. Carpenter? Was it in her hair? Was it on her face? Judge Bean, you know that they checked the drains, they checked the car. Judge, DPS checked the car. And it was filthy, by the way. It had dog hair in it and clothes and junk. And so there's no way it could have been clean. My esteemed colleague from the Attorney General's office claims that Mrs. Carpenter could have thrown away the bad clothes. Judges, she would have to have planned this to the extent that she was wrapped in saran wrap and that she was, a sort of ninja warrior to get no blood on her and then go and dispose of it, and then be so stupid to lead the detectives through her home. In the video, she was like a hostess. We'll look in here, we'll look in there. The state relies upon her conduct to convict her, but we don't know how people are really going to act. We don't have a science based upon that. That's because we don't do tests about murdering spouses and loved ones. And if you recall, I think she's a sergeant, I can't remember, Detective Cahall said, people react differently. They don't always call 911. They don't first. They call loved ones. They called friends. Judges, the government, is using strictly her behavior, nuances of behavior to convict a woman of first-degree murder. So in Glissendorf, they said, the defendant needs to show prejudice. How much more can you be prejudiced by the failure to preserve evidence that is so accessible that your sergeant tells you twice to take it? And then they failed to preserve photographs of blood spatter at the scene. And my colleague would say, well, not every subject or defendant whose investigators failed to do something is going to receive a Willits instruction. I would agree with that. The case where they had the black and white photos instead of the color photos, I don't think that fellow may have been able to show the extent of the prejudice that would be necessary for a Willits instruction. Sure, color photos would have been great, but as my colleague would tell you, every investigation has could be improved a little more. This investigation was not tantamount to an appropriate homicide investigation. It's not their fault. They didn't have the skilled personnel available, but not to take the clothes. And you can't say that
How would an earlier seizure of the clothing resulted in test results of greater exculpatory value, Mr. Bloomberg?
Because the jury asked, Judge Bean, during the trial, did she wash those clothes? That shifts the burden to my client to show that oh no, I didn't wash them or clean blood from them. It's wrong. The government should have acted to secure the evidence, and their failure to do so, their unwillingness to act, their negligent manner by doing so, denied her a fair trial, the kind of trial that the justices talk about in Jackson versus Virginia. And in this particular case, my esteemed counsel would probably tell you that I'm sorry, that skips my mind what we were talking about. I'm sorry. So I have 6 minutes and I have about 40 seconds left. I'd like to preserve 6 minutes. I'd also like to talk about not just the Willits instruction, but the failure to grant the Rule 20 motion for judgment of acquittal. And that brings me to cases like Mathers, and in State v. West, they define the rule, and it talks about substantial evidence, and has to be proof that reasonable persons could accept as adequate and sufficient to support the conclusion of defendant's guilt beyond a reasonable doubt. But it cites to Jackson versus Virginia, which develops the Winship doctrine, and I'm not going to save as much time as I thought I would, judges, but in Jackson versus Virginia, they talked about that this requires more than simply a trial ritual, that the fact finder must rationally apply the standard. And the judges, there is no evidence that could be rationally applied where reasonable men could differ. This is a case of actual innocence. She couldn't have done this with her character and the style of the murder and the fact that there is not one iota of physical evidence.
So, weren't you, by making this argument below, weren't you asking Judge Campbell to act as the 13th juror in effect of saying reasonable minds can't differ on this? But if reasonable minds can differ on the inferences drawn from the facts in the case, it has to go to the jury, correct, Mr. Bloomberg?
Sure. If reasonable minds can differ, then there is substantial evidence. Would you agree, Your Honor?
I would agree.
And I may have misstated the rule when I was arguing, but I also argued in a motion for new trial, I believe, that she should act as the 13th juror under Clifton, the Clifton case, in my motion for a new trial, because at that point in time, the jury had already made its verdict. I think this is the one at the close of the state's case. I'm entitled to it regardless of what I say. It's the judge's duty to determine legally it either is or is not. There either is or is not sufficient evidence. And in this case, but you have a de novo review duty as well. So when the government would say, don't reweigh the evidence. Well, in a sense, you have to reweigh the evidence because you have to determine whether or not a Rule 20 motion should have been granted. And in a case like Mathers, where Justice Mueller determined that Mr. Mathers, sure, he was there. He had there was talk of him being in Yuma, Arizona from California, and he put the guns in the trunk. But we don't know what he did when he got to Arizona. We don't have any evidence. There's no evidence to convict Mrs. Carpenter other than it's a convenience. She's a person of convenience, and this is why she waited. They waited for 10 years to bring her to trial because there was no case 10 years earlier. And there's no new evidence, admittedly, by the government, no new admissible or relevant evidence. They had a psychologist who wrote an email. And then they had an ex-cop, McLeish, who judged her statements by her uhs and ahs and use of chosen words. This is not the type of evidence that we have classically used in these courts in homicide cases. Homicide trials are not new. They've been going on for a couple centuries in our country, and you can't throw personal matters into this, but this is really not evidence that is utilized to convict. So I will reserve the 2.5 minutes. Thank you.
Oh, Counsel. Thank you. Mr. O'Toole.
Good morning. Assistant Attorney General Michael O'Toole on behalf of the state. If you have two people in the room and one walks out and the other one's face down in a room with a knife in the back, it's not too hard to figure out who did it. In this case, really, it's not that much different than that hypothetical. No one else had the opportunity. No one else had the motive. No one else could have done this. In addition to the general circumstances and the timing of the offense and the motive of the defendant, we also have a statement to an acquaintance indicating that the victim was killed in part by a slice across the throat. That was not information that was disclosed to the public, and therefore that admission to the acquaintance by the defendant was really tantamount to a confession. I know they attacked this witness's testimony at trial. She had her nervous breakdown at one point, but she was adamant that the defendant made this statement a day or two after the murder, before the defendant would have had time to go to the funeral home and possibly learn, we don't know, but possibly learn at that time that there was a cut to his throat. So it's not, this court can't reweigh her credibility. The jurors had all that information before them, and that's a very important piece of evidence here. But we have other evidence additionally. I mean, one of the most compelling things to me personally is the fact that the defendant claimed when she got home she didn't notice the knife in the back. I mean, you look at Exhibit 50, there's a knife smack in the middle of the guy's back. He's laying face down. There's two big rocks next to his head and a huge pool of blood. This is clearly a murder scene. And the defendant, who claims she's an artist and a visual person, says she didn't see this initially. That is incredible to believe. So incredible, it's contradicted by the evidence, in fact. It was when she first calls 911, she says, when she talks to her sister initially, she says she walked in, he stabbed in the back. So she's making an inconsistent statement, but she wants to get her friends over, Gary and Jane, to see what she saw and hopefully somehow basically get some confirmation that she walked in on this kind of scene. But it's all very muddled, doesn't really make sense, and her behavior and her inconsistent statements are very telling here.
Mr. O'Toole, as Mr. Bloomberg stated in his comments to the court, I believe in looking at the Rule 20 argument, or part of the record that I read in preparing for this case, Judge Campbell, I believe, said that, that's more akin to a Willits instruction, kind of intimating that there would be a Willits. In your review of the record, do you have any, you shed any light on the fact of what maybe Judge Campbell did in terms of changing her mind and not giving a Willits instruction?
I know initially, early in the trial, there was some suggestion, I forget exactly in what aspect, there was 5 or 6 different things. There was some lost tapes, I believe maybe that was what was going on with that. Those tapes were arguably a lost tape. It's unclear. The judge basically said, assuming it did exist, it wasn't prejudicial and a Willits wasn't warranted. So I'm not sure if that what she's referring to, but the court's Willits ruling is very extensive, and opposing counsel talks about the trial judge being making sure the playing field is level. I've never seen a more careful trial judge in my life. Gave each party an opportunity time and time again to make their positions known to the court, has very detailed findings for most of the issues raised on appeal, and of course these issues, the Willits is reviewed for abuse of discretion. The main one, I guess opposing counsel was talking about, the main aspect of Willits was the clothing, but as the trial court found, there was no destruction or loss of the evidence. It was basically just delayed, and there's no indication that further or earlier testing would have revealed anything. And also, too, I think basically everyone acknowledged that she did not commit the murder in these clothes. It just would have been impossible based on the defense experts' statements, and even the state's detective saying, no, you couldn't have done that and had clean clothing, and she only had like a small dot, which would be consistent with, having some kind of secondary transfer after she had changed her clothes. So again, it's abuse of discretion. The court here heard all the evidence and had the best view of putting this request in context. And unless the court has any other questions, we ask that appellant's conviction be affirmed.
Thank you, counsel. Mr. Bloomberg, rebuttal.
Thank you, Your Honor. A few short matters. At page 29 of the appellee's brief, the government agrees that it would have been preferable to collect the clothes on June 4 instead of June 5. And I think that puts the issue about as mildly as one could possibly put it. It is truly like night and day collecting it on the 4th when nobody could tamper, when the police were in control, and June 5 when the jury believes that Mrs. Carpenter nefariously could have done something to fix the clothing so that the blood no longer showed. This destroyed Ms. Carpenter's opportunity.
Did the state argue that at any point?
No, they said
that because it was a day late, they collected a day late and there was virtually no blood on it. Did they argue to the jury that she must have cleaned her clothes?
No, I think we had some in limine discussions about that, and they did not, Judge Bean, but they didn't need to. It's the jury that brought it up. So, because now we have questioning by jurors And so it's it's not a new thing for me, but I was back in the day when they didn't have questioning for
So was
jurors.
I.
Yeah, and they now have questioning and they've had it for a decade or more. But the point is, you have to then, it's a new part of the golf game, so to speak, because now you have to develop and again, I told you about the fear with the Judge Keene situation and the right to left versus left to right. But in any event, the jurors told us that this was on their mind because they asked, did Mrs. Carpenter wash her clothes? Was there any detection of that by the detectives? Did they, test it for soap suds or some such, kind of thing? I'd like to draw your attention, if you don't mind, to People v. Blakesley, which is a California case. It's cited in our final brief. It's 2 California App 3rd, 831. It's a 1969 case where Teresa Blakely discovers her mother's body, and she's shot 5 times with, they believed it to be the .22, but it had the hollow point bullets, so the bullets were destroyed, and they had a detective who said it looks like it probably was a .22, which the brother Michael owned. But the brother Michael had a decent alibi to Teresa Blakely. And Teresa was kind of hanging out around the home. She went out a little bit. She was talking to a neighbor. And she had quarreled with her mother. And the judges of appeals said, everybody quarrels with their mother. Kids, 18-year-olds quarrel with their mother. That's not evidence. Mrs. Carpenter swore at Brent. She used common foul language. And, listen, she's a fun kind of thing. People swear when they're in casual settings. There's some people who do that and some people who don't. And she had a mouth. That doesn't make a person a murderer. So all the evidence weighs in her favor of her innocence. She was entitled to the Willits instruction. A Rule 20 motion should have been granted, and this is certainly her last opportunity. Thank you.
Counsel, we appreciate your argument today. We appreciate your briefs. We will take the matter under advisement. We'll issue a written ruling in due course. Thank you. We stand adjourned.